evening, everyone. Thanks for joining us for the August 2022 monthly Labourlaw update. Um, we couldn't at least come across any kind of amendments or ordinance for this month by any state or the central government. So this we don't have much to share in this segment. As far as the circulars and notifications are concerned, the Kerala government has amended the rules under the Kerala Shops and Commercial Establishments Act. Primarily, they have taken most of the rules which required physical filing. From there, they have moved to an online portal and they've taken things online. So to that extent, in the process of their ease of doing business, they have made some amendments to the rules and forms under the Kerala Shops and Commercial Establishment Rules 1961. The Himachal Pradesh government has permitted engagement of women in night shift. In various other parts of the country, this has already been done. Similar rules have been laid down by the Himachal Pradesh government as well as to when they either when women employees engage between 7 p.m. and 6 a.m. the following day, what needs to be followed. There are different rules that have been given, and a circular has been issued to that effect by the Himachal Pradesh government. Once again, the Delhi government also taking things online has provided that certain exemptions can be applied only online. There's no other way of entertaining, and physical applications will not be entertained. And similarly, under Delhi Shops and Establishments Act. In state of Tamil Nadu, Ramanathapuram and Sivaganga district, various provisions of the ESA Act have been extended, and the central government has passed a notification to that effect. In this month's quiz segment, the question is: a supervisor is a worker under the worker under the IR code or not? And your choices are there. Please do post your reply in the chat box. You shall see the answer at the end of the program. We have touched upon this earlier as well, this topic, dispensing with domestic inquiry. As you're all aware, there is no statutory requirement to hold a before terminating the services or taking any kind of disciplinary action should initiate domestic inquiry is not provided under any statute. It's more a judge-made law based on which, in order to give an opportunity to the concerned employees, the law requires the employer to hold a domestic inquiry. Standing orders also provides for it in certain states. But there have been cases where employers have proceeded against employees without any kind of inquiry, and in such cases, the Supreme Court has also upheld it. So, for instance, in this case of Indian Railways was one of where violence, and holding an inquiry they thought would give scope for more violence and the concerned employees acting in a violent manner. So they dispensed with the inquiry, and the Supreme Court held there's nothing wrong about it. The situation so mandated, and the employer had taken a call and therefore upheld the termination. This is one more case of where the manager was thought to be assaulted by a lady who was dismissed from this case, and it went on. And again, considering the grave nature of the misconduct, they felt that not holding an inquiry is inquiry can be dismissed with, and merely because inquiry was not held, it cannot be said that dismissal is bad. These are again few more cases of where it has been held that inquiry is not. But if you were to dismiss an employee without holding an inquiry, the burden is upon the employer to prove the charge if the termination or dismissal is challenged before the labor court. So that's where the crux lies in whether you need to hold a domestic inquiry or not. Would you be able to prove the charge if questioned? As an employer, will you be able to do it? Is the issue to be seen before dispensing with an inquiry. Of course, there are judgments to also show that say that's not mandate. But the crux lies is that management can dismiss an employee by dispensing with inquiry. However, that will be an exception and it's not the rule. It should be that the employer had to dispense with the employee services without an inquiry because of the grave misconduct, or the employee made it impossible for the employer to conduct the inquiry. And the disciplinary authority should have reasons to justify as to why the domestic inquiry was dispensed with. And in the event of the domestic inquiry being dispensed with, the burden is on the employer to prove the charge for which the employee was dispensed with. There are practical challenges that come about with this. For instance, if you were to dismiss an employee today in 2022, and he challenges it before the labor code, and the case comes up for trial somewhere in 24, 2 years later, your witnesses might have disappeared. They could have gone elsewhere. They could have taken up employment elsewhere. Your witnesses may not have a clear thought on what happened about the incident. So there could be a memory lapse as far as the witnesses are concerned. And therefore, it is in the best interest of employers to also have the domestic inquiry. It's only in grave situations where it's an exceptions alone that you will dispense with inquiry. So this is the law on the subject. In our next segment of Know Your Codes, if you look at it, it's not something new, but the term used in Code on Wages, the term used is employee, not worker. If you look at OSH code 27 for overtime, it uses the word worker. If you look at your Sharps Acts, again there it may be a wider ramification, but under Sharps Act, managers are exempted. So what we thought of pointing out in this segment here is that the word used is employee, and therefore the payment of overtime may arise for all employees, including managerial persons. And third-party audits and certification, it's also already there to some extent, but not been there effectively used. The OSH code provides that the appropriate governments can formulate schemes for empanelment of experts for third-party audit and certification, and then also give them the powers to carry out these third-party audits and certification. So given the appropriate, if as and when the codes are implemented, representations should be given to the appropriate government for more third-party audit and certification. The National Skill Development Corporation has started a very ambitious project of skilling 75,000 people and upskill them as part of the Delhi Municipal Corporation Council decision. I mean, in association with them, sorry. The pension under the Provident Fund Act, where the pension contribution was being capped to the ceiling limit, and after 2014, who can join it? And these aspects, already the Supreme Court had decided against, I wouldn't say against employers, but had upheld the amendment scheme, against which the review was filed by the EPF department. Sorry, it didn't upheld it. It said that they could still ask for a higher pension, and EPF department had filed a review petition, and that has now been heard by the Supreme Court, and orders have been reserved. This will have quite a ramification with regard to the pension that an employee will earn under the EPF Act, especially if he has contributed not on the ceiling, but even beyond the ceiling. The pension contribution has been on the actual earned salary and has not been restricted to the ceiling under the EPF Act. The Minister of Labour, central government, has indicated that India is in the process of negotiating SSAs with US and UK. We already have SSAs with many countries. Now India is also trying to get SSAs with US and UK. In the case law segment, we are looking at first a judgment under the Maternity Benefit Act. In fact, it didn't arise under the Maternity Benefit Act. The question of maternity benefit or maternity leave to an employee, the petitioner herein, she married a person in 2014, and that person was already married earlier, and he had 2 kids. And after his wife died, his first wife died, he had married the petitioner herein. The petitioner had registered the 2 children from the earlier marriage of her husband. And when she had her own biological kid, she applied for maternity benefit and it was rejected, saying you already have 2 children. The Supreme Court has said that is not the criteria. Biologically, she was giving birth to a child for the first time, and therefore she will be entitled to the benefits of the maternity benefit. And to that extent, the recent ruling has been given by the Supreme Court. This is a case of where an employee had worked as a temporary worker, and this period was not being reckoned for the purposes of gratuity calculation after his retirement. The Karnataka High Court has held that any period, as far as the worker has worked for the minimum number of days in a year, irrespective of whether he is called as a badli or casual or temporary worker, that period should be reckoned for the purposes of calculating gratuity. Third is about an NGO, whether are liable to be covered under the ESA Act. The Madras High Court has held that an NGO is not doing any commercial activity, but it's only a philanthropic activity. It will not come within the definition of a shop or commercial establishment, and therefore it need not be covered under the ESA Act. In the Lex Posh segment, looking at a Posh judgment again, this is a case of where a complaint was launched by a women employee. The IC comes to the conclusion that there is no harassment. The relationship between the complainant and the respondent was mutual with full consent, whatever had happened. Thereafter, the IC recommends that their conduct, their personal conduct, the personal relationship between the 2 persons should be investigated and appropriate punishment should be imposed. Challenging such a finding, rendered an observation made by the IC in its report. The employee concerned had filed a writ petition. The High Court held that the IC can only look into whether there is a harassment element, whether there was a sexual harassment. It cannot go beyond that to give directions to the employer or even give any kind of recommendations to the employer, especially in respect of a complaint which is private in nature. It's not harassment. So we have the answer for the quiz question. Anybody drawing salary less than 18,000, even if they are doing supervisory work, would be coming within the definition of worker under the IR code. The complaints calendar for August 2022 is provided here. We shall also share it within our PPT to all the participants here. Thanks for joining us, and we hope to see you again on 24th September at 4 p.m. Thank you.